Yes, sir.
Small on it.
Just going through that, Judge, there are certain offenses for which there is no sentence. The burden of those counts would be, in essence, vacated or whatever. But to begin with, the state filed a notice previously of its intent to use the prior conviction in aggravation of sentencing, and that is applicable to 13, 14, and 18, for which he was convicted, and that was under 17.7B2. In that instance, he would be required to receive a sentence of life without parole on those particular counts, irrespective of whether or not that is required, because our position has to be we've gone through basically the counts for which he was found guilty, and I can go through those and make sure that y'all have that as far as what we indicated. Of course, count 1 is life without parole. Counts 2 and 3, those murders, there would be no sentence on those at all. They would not even merge in that regard, since those would be contained and dealt with under the malice murder. In regard to the aggravated assault on a peace officer with a weapon, count 4, as well as count 5, possession of firearm back to convicted felon, those would merge into the sentence of count 1. Of course, he
Counts 4 and 5?
Yes, sir. As 5 was the underlying felony for count 3, felony murder. Okay? All right. As far as count 6, 7, and 8, Officer Cody Howard, it's our intention that count 7 and 8 would merge into count 6, the criminal intent to commit murder. That'd be a maximum sentence of 30 years for that particular. As far as count 11, the aggravated assault, that would against John Brooks, the maximum sentence would be 20 years on that. Count 13, the kidnapping with bodily injury, that should be a sentence of life without parole under the notice that we filed. As far as count 14, the armed robbery against Deborah Lumpkin, that would also be one that life without parole sentence would be required. In our contention, whether it's required or not, that would be the appropriate sentence. Counts 15 and 16 against Deborah Lumpkin, aggravated assault with intent to rob, aggravated assault with deadly weapon would merge into count 14. Count 17 is hijacking a motor vehicle. And that would not merge, of course. And that carries a sentence of 20 years. I believe it has a minimum of $10,000 fine. Count 18 is a kidnapping. It also would have a mandatory life without parole in that instance, based on the notice that we filed. Moving ahead to the other counts here. Count 50 would be a sentence of life with parole as set by the jury. Count 51 and 52, there would be no sentence put on those. 53 and 54 would merge into counts 51 and 52. Or 51, 50, I'm sorry. Would merge into count 50.
53 and 54?
Yes, sir. They would merge. 51 and 52 would be no sentence. And the remaining counts 55 through 70. Sorry. 55 through 70, except for 57, which is the possession of a knife. Those other counts carry a sentence of 15 years.
And the knife is 5.
And the knife is 5. So that's where we stand on those matters. That's what y'all have. That's what we have. There was the be 4 life without parole sentences and 1 life with parole, as well as possibly other sentences running consecutively.
Should.
And I'll have recommendations.
If you want to be heard on
I've done enough talking, Jerry. Been talking for a couple of months, and I just have nothing to say. Just let it play, of course, whatever you know. I don't think I'll make too much of a difference what you rule is, but I will say this if I can. Okay. Yeah.
that. Does it have to do with sentencing though?
I don't know. But I just won't say that.
All right, do you want to be heard further, Mr. Long?
Okay. In regard to this matter, I think you've heard from all the victims here, the impact that it had on their lives. I think there's more to say about that. I'm going to speak particularly about the folks who were held over there at Creekstone in that regard. The jury did have a finding in that regard that they had possession of a firearm during the commission of each of those crimes at that point. They found them not guilty of the crimes themselves. There was a finding of possession of firearms during the commission of those crimes. And it was certainly a finding on their part that there was criminal responsibility on the part of the victim. It is our position based on the conduct that occurred from December 28, 2010 through March 25, 2011. This conduct is unlike anything we've seen in this county in my memory. I've been living here and working here during this time. With all this, he or she has put the maximum sentence. If all the life without parole will run consecutively to each other, the life with parole runs consecutive to that, and all other sentences should receive the maximum sentence running consecutive to all that and consecutive to each other. I don't think there's any question under all the circumstances what happens to the sentence of all that. It's our quick condition being 300 years. That would be added to the life sentences of the
Yes, sir. No, sir.
You know, oftentimes in a criminal case, I'll make some comment or about the case. When you consider the enormity of these events and the tragedy, I cannot think of anything that I can say that does anything other than diminish what has gone on. I mean, there's no way to bring that into a 5 or 10 minute statement. It can't happen. So I have nothing to say. I think the acts, tragedies, the impact on these families that is going to last for generations. Says more than I could ever say. All of these families, the Christian family, the Wray family, the Howard family, their lives are changed for generations. And I understand. But I am going to make one other point, because I sit up here in my courtroom day after day and hear about marijuana cases that are just a little marijuana and that sort of thing. And I will always remember that this case, a series of events in this case, started with a little marijuana. And I'll never forget that. good, I'll sentence you as follows. Count 1, malice murder, life without parole. Counts 2 and 3, no sentence. Count 4, merge into count 1. Count 5, merge into count 1. Count 6, 30 years consecutive. Count 7, merge into 6. Count 8, merge into 6. Count 11, 20 years consecutive to 5. Count 13, life in prison without the possibility of parole, consecutive to 1. Count 14, life in prison without the possibility of parole, consecutive to 13. Count 15, merge with count 14. Count 16, merge with count 14. Count 17, 20 years consecutive, $10,000 fine. Count 18, life without parole, consecutive to count 14. Count 50, life, possibility of parole, consecutive to count 18. Count 51, no sentence. 52, no sentence. 53, merges with count 50. 54, merges with count 50. Count 55, 15 years consecutive. 56, 15 years consecutive. 57, 5 years consecutive. 58, 15 years consecutive. 59, 15 years consecutive. 60, 15 years consecutive. 61, 15 years consecutive. 62, 15 years consecutive. 63, 15 years consecutive. 64, 15 years consecutive. 65, 15 years consecutive. 66, 15 years consecutive. 67, 15 years consecutive. 68, 15 years consecutive. 69, 15 years consecutive. Count 70, 15 years consecutive. That will be the sentence. Mr. Hood, I am required to tell you on the record that you have the right to seek post-judgment relief from your convictions of these crimes by making either a motion for a new trial and/or appeal to a higher court. If you choose to file a motion for a new trial or an appeal, you will need to file that motion and notice of appeal with the clerk of Superior Court of this county within 30 days. I urge you to discuss that with an attorney. You have a right to have an attorney represent you in a motion for a new trial and the first level of direct appellate review. You can afford to hire an attorney. The court will provide you an attorney and a transcript of the trial for you at no cost. If you are electing to proceed pro se on that, I need to inform you that you have a right to seek post-judgment relief from your conviction by either yourself making this motion for a new trial and or filing an appeal to the higher court. If you want to make a motion for a new trial or an appeal, you will need to file this motion yourself within 30 days with the clerk of Superior Court of this county. If the motion for a new trial is made and the court denies it, you will have 30 days from the filing of the order of denial in which to file with the clerk of court your notice of appeal. I need to ask you, do you understand that you have a right to have an attorney represent you on the motion for a new trial and the first level of direct appellate review? You cannot afford to hire an attorney.
Yes.
Also, do you understand if you cannot afford to hire an attorney, the court will provide you an attorney and a transcript of the trial at no cost to you?
Yes.
I need to further tell you, if you do decide to represent yourself, you understand an attorney is trained to understand court procedure and proceedings for motions for new trials and appeal, knows the strict requirements of practice and procedure for motions for new trial and appeals, how these requirements may affect and even cause you to lose your right to a motion for a new trial and or appeal. An attorney has studied the law, what is complicated in the related parts, and knows how to research the law, including the most recent developments that may apply in your case. As an attorney will have studied and knows how to organize and prepare the necessary documents for your motion for a new trial and appeal based on the art of persuasive legal writing with its logic and methods of citation, technical terms, and accepted spelling and grammar. The attorney will know your rights and liberties, how they may be affected by the court, and how to better protect them. The attorney would know how to present and argue your case in all matters favorable to you, to the trial court, to the appellate court, all of which you may not know. To be clear, do you understand that post-judgment practice involves strict compliance with rules of practice and procedure?
Yes.
Do you understand that your failure to comply with these rules may result in a waiver or giving up of important issues?
Yes, sir.
Do you understand that if you represent yourself, you are generally bound by the same rules of practice and procedure as a lawyer?
Yes.
Do you now understand your right to be represented by an attorney during these proceedings and the danger of going through them without an attorney?
Yes.
Do you know that you wish to apply to have the court appoint you an attorney at this time?
But I don't really feel like talking about that, Judge.
That's fine. But you understand that the
Yes.
time frame starts and goes on?
Yes, sir.
Let me know. I find that you understand your rights and obligations and responsibilities regarding the next step in these proceedings.
Yes.
I also need to advise you that in a felony, you have at least, you usually have a period of 4 years from the date that your sentence in this court becomes final, file a habeas corpus petition. The details that can affect the time within which you must file this petition are contained in a copy of the code section that is being handed to you now. Ms. Slayton? Any other matters?
Judge, I've been asked to, should y'all release the issue of restitution over the
Mr. Seuss.